morning.
Morning, Ms. Goodman.
Good morning, and may it please the court.
You don't have your opponent yet showing yet, so. There she is. Hi, Ms. Lawson. Okay. Ready to go. You're up, Ms. Goodman.
Thank you. Good morning. May it please the court, counsel. And before I begin, may I please reserve 5 minutes for rebuttal?
Sure.
My name is Olivia Goodman, and I represent the appellant in this matter, Broderick Karszewski. Mr. Karszewski was tried in Hillsborough County in 2021 on a single count of lewd and lascivious molestation of a child under 12. The facts underlying this incident are a single occasion in which the complaining witness alleged that her genital area was touched inside of a restroom at the Busch Gardens theme park in Tampa. Mr. Karszewski raised 3 overarching issues on appeal and 1 claim of cumulative error. And I would like to begin by addressing point 2, subclaim 1 of Mr. Karszewski's appeal, which is the denial of the motion for new trial related to this discovery violation and related to the material change in testimony from the complaining witness. And I believe that the salient facts in this matter begin essentially at the case's inception. At all times prior to the trial preparation phase, the immediate trial preparation phase, the complaining witness, the minor child, alleged that this touching event occurred inside of a single stall restroom, which was located inside of a freestanding restaurant in Busch Gardens. And she testified to this very explicitly and directly in her deposition. When asked, she reported that the companion restroom was inside of the grill restaurant. And it was not until immediately preparing for trial that the defense became aware that that was an impossibility. There was no such restroom inside of that building in Busch Gardens. There was only male and female restrooms with multiple stalls. And at that point, the state was made aware that there was this discrepancy. The state, it's undisputed that the state discussed this issue with the child and the child's family, and the child was then taken back to Busch Gardens by her family to look for a restroom that would fit her story. And at that point, the state disclosed to the defense a second restroom, which was completely independent from the grill restaurant. However, importantly, it was not the first aid station that would ultimately become important during trial. And I would submit at that point in the trial preparation phase, it was reasonable for the defense to go forward with trial prepared to impeach the complaining witness with her prior deposition and lay that issue of credibility out as she's now changed her story as to where this event occurred. However, I don't believe that the defense could have been prepared for the witness to get on the stand and allege at trial for the first time that this event actually occurred in a third location, which was a first aid station, a companion restroom inside of a freestanding first aid station, which was once again separate and apart from the restaurant.
But Ms. Lawson, you went to trial knowing that her deposition testimony about where it occurred could not have been possible, right? So while you were prepared to establish that that was absolutely not the case, certainly you should have anticipated that there might be, a response to that in some way. So It's hard to see this. It's not a Richardson violation. Nobody withheld a witness or withheld a document or withheld anything. If anything, it was a under 12-year-old who was confused about the facts of a location, which occurred several years before. And you established before trial that where she said it happened couldn't have happened. Therefore, you must have anticipated or should have anticipated some type of response to that, right? So it's not like somebody withheld information. It was a misstatement in a deposition years earlier, either intentional or unintentional. I would suggest that a child is going to get mixed up by these kind of things. But you went in there knowing there was a problem, so you weren't surprised by it.
Well, Your Honor, I would disagree with that statement. And just as a point of clarification, I was not the trial attorney in this case. However, I would agree that at the time that the second bathroom was disclosed, that the defense attorney was, and I believe should have been, prepared then for this change in testimony. And that's the point that I believe the defense went to trial prepared to impeach the witness on. Absolutely. I would agree with what you're saying, that that is an issue that could be laid out and with cross-examination could be explored. Where I would disagree with what you're proposing is that the defense could have anticipated this third location. And if it were just a simple matter of, okay, it's not the first location that she initially stated, it's not the second location, but it is just another independent bathroom, then I think that this issue would be harmless at best. However, what we're dealing with here is that she specifically alleged at trial for the first time that this was the first aid station. And that was not something that could have been explored on cross-examination because it required the testimony of an additional witness that would have been called at trial. And that was demonstrated at the sentencing hearing where the defense called Nicholas Ramongo, who was an employee of Busch Gardens Tampa, to testify to the facts surrounding that first aid station. And he explained during the motion for new trial, and I would submit that he would have explained had he been called to testify at trial, had the defense been aware of this change before trial, that that first aid station is manned by an employee. And that there is a employee there at all times for the express purpose of assisting any guests that will enter through the guest entrance into that first aid station.
But the victim at trial was substantially impeached in cross-examination by this, so it's hard to see the harm. I mean, the jury may not have heard the challenges to the first aid station bathroom having to sign in and such, but they certainly heard that when the victim was deposed, she'd picked another bathroom. So whether it's this bathroom or another bathroom, she was impeached. But with her deposition that said, that's not what you said earlier, you know, you said this instead of that. So what that is, does it really matter that much? Which bathroom it is? It wasn't the one she said. That's the bottom line. At least that was her testimony, that she picked a different bathroom.
Well, Your Honor, I would disagree to an extent with what you're proposing, because I do think that the witness certainly was thoroughly impeached, because there was almost no portion of her testimony that was the same from deposition to trial. But regarding the specific issue of the restroom, I would actually disagree that she was impeached. And what I would say is that the defense made it a large feature of their case during their opening statement. But at the time then that the witness gets back up on the stand and she says, oh, it's a first aid station, it's right by the grill restaurant, I don't think that issue was ever revisited by the defense on cross-examination. And I believe that the reason for that, although I'm not the trial counsel, so I'm only inferring by what I have from the record, is that it was unclear whether or not she was returning back to the first statement that she made regarding the bathroom being inside of the grill or right next to the grill, connected to the grill. And that's because the defense couldn't have been prepared with any information about this first aid station and where it was and how it fit into the story and how her testimony was now changing again. But I would certainly agree that the defense went to trial and was able to make a change, at least a feature of their opening statement. And I believe that they mentioned it in closing again, but it wasn't until trial had ended and until, actually, let me rephrase what I was about to say. I think it was right as trial was ending, the defense alleged in their motion for new trial that they were able to speak with the witness that was listed by the state, but was never called by the state to authenticate a map. And that was when the defense first learned of the facts of the first aid station and how monumental this discrepancy really was. And that was after it would have been possible for the defense to recall that witness for purposes of trial. And that's how the issue ended up in the motion for new trial posture.
Okay. Do you feel like, I'd like to shift to another area, but I don't want to take you away from this if you still got things you want to tell us. Can I shift to another area of your
Absolutely.
brief? Yeah, I'm particularly concerned about the second motion for new trial based on juror misconduct. And what I'm specifically concerned about is the timeliness or lack thereof of that motion. Would you help me understand that better?
Absolutely. So the timeline of this case, it's procedurally, it's very unique. There's a second motion for new trial. It became evident after the jury verdict and after the first motion for new trial had been filed that there was an issue of jury misconduct. And that issue essentially related to a juror, Travis Stevick, materially misrepresenting himself, his history, and in some respects, actually reinventing portions of his history during his jury selection process while he was answering questions under oath. So at the time that trial went forward, Travis Stevick was accepted onto the panel without anyone realizing that he was not being truthful. However, right after the verdict, the day after the verdict, a private investigator service was brought onto the case to investigate specifically the jurors.
Let me just interrupt you there for a second. I mean, he clearly said in his questionnaire things that he said differently when he was asked questions. So there was actual knowledge right away that when he was asked questions in voir dire about law enforcement background and things like that, they were directly contradicting what was in his questionnaire. So there was a known at that moment that he wasn't truthful. Am I right about that?
I think that's a fair statement of the facts, but to the extent that I think that it's perhaps maybe it is something to note that there might be discrepancies between a juror, what they were written in their questionnaire, but not to the extent that it would become known that he was misrepresenting himself after.
I mean, if I recall correctly, he said in his juror questionnaire, he didn't have any law enforcement background. And in the voir dire questions, he claimed to be a corrections officer. He claimed to be a sheriff's deputy. I mean, that's a pretty big misstatement, isn't it?
Absolutely. I agree with that, Your Honor. I think it's possible that the trial attorneys at the time would not note that discrepancy, but I can't disagree that I consider that to be a huge discrepancy.
Well, they have the questionnaires. I mean, I was a trial lawyer once, and I know that you conduct voir dire with the questionnaires in your hand. So I would imagine, and commonly you have the questionnaire in your hand as you're asking questions, and so it's hard for me to understand how that could be missed. I mean, it was known up front. So while there's a lot more things came out after the investigation, no question about that, lots of stuff came out. But this very key misstatement was known on the front end.
Yes, and I can't disagree with that, Your Honor. I can't disagree that the trial attorneys should have perhaps caught that issue. And I would be speculating if I spoke to why they did or didn't. But in any case, I would still assert that the juror questionnaire and then of course the questioning under oath, it's possible that Stevick, I think at that point, would still receive the benefit of the doubt by the trial attorneys in deciding whether or not they were going to accept his responses under oath as being truthful, which they were not. Of course, they were shown to not be.
So let me take you back to drilling on the timing of this motion. Was it timely or untimely? And if not timely, is there a reason it should have been considered timely?
Well, I would submit that the motion itself, I think the motion itself was not timely under Rule 3.590. It was not made within 10 days, and it was not made within the time of the before a ruling had been obtained on the first motion. That the motion itself. However, I would submit that the information was known to the trial attorneys and the court at the time of the sentencing hearing and prior to the sentencing hearing. And that's evident on the record because the sentencing court noted before the appellant's family member testified that they had read the letter, and then that information was shared at the sentencing hearing. So in that respect, I believe that the information in a sense sort of relates back to the date of the sentencing hearing.
So we're going to write an opinion reversing on the motion for new trial and find that it's timely. What are we going to point to for authority that says we think it should have been accepted as timely?
I think this is a very unique case, and so I can't say that I have authority indicating that the motion could have been accepted as timely. I think that Nicholson, which I believe was cited by the appellee, is distinguishable in the way that there was a pending motion for new trial. But at the same time, Your Honor, I would submit that the option of pointing only to the motion for new trial, the successive motion for new trial, is not this court's only option of reversing this matter on the jury misconduct. That issue was raised in multiple respects in appellant's briefs, and I would submit that this court does have the option of reversing in the interest of justice, and specifically on the issue of fundamental error of this issue discovery after the time of the verdict and not before the sentencing hearing. And in that,
you're at your rebuttal time, and you use your minutes as you wish, but I just wanted to give you that heads up.
I'll keep my mouth shut.
I will just
rare occasion.
I will just briefly conclude, as I know I'm now in my rebuttal time, but I would submit that this issue can be considered under the fundamental error standard. It is certainly an issue that goes to the foundations of due process. So even unpreserved at trial, it goes to the most basic minimal standards of due process to have your trial conducted before a fair and impartial tribunal. And I would urge this court to consider this matter under the De La Rosa factors that were set out, which is, in my opinion, and what I submit to this court, which is the appropriate procedure for a case that is at the direct appeal posture, rather than a post-conviction case. With that, I'll open myself up to any last minute questions, but of course, we're not abandoning any issues. I'll rely on our other issues as pled in our brief, and I'll save the remainder of my arguments for rebuttal.
And you got just about 4 minutes left.
Thank you.
Ms. Lawson?
Good morning. May it please the court. I'm Sonia Lawson with the Attorney General's Office on behalf of the state of Florida. And I'd first like to reach the issue of the fundamental error standard being used as a justification for this untimely motion as to the juror misconduct. In order for that, for there to be a fundamental error, there would have been had to be blatant, direct evidence of the misconduct, and we don't have that here. Certainly, the defense team had an opportunity to interview this witness when they discovered what they considered to be inappropriate 2 months in advance of the court's ruling, and that didn't happen. And even looking at the nature of the information that was discovered about this juror, there isn't anything in there that points to bias with respect to this lewd and lascivious claim.
Well, I mean, it's really clear that the jurors' misrepresentations were extreme. There were lots of misrepresentations. And this defendant got a 25-year minimum mandatory sentence and a lifetime of sex offender probation in the face of a juror who really made a lot of serious misstatements. And you know, the struggle is the timeliness of the motion. So if the motion is in fact untimely and there's nothing we can do about it, does this defendant have a remedy under Rule 3.850?
Well, I think in this case, he may have, but the posture with respect to this case, procedurally, not here. When you look at the things that were raised in this juror's background, it's just hard to place a bias because I don't think that those things align. The allegation was raised that he
Well, he was a member of an organization that openly targeted offenses like this, you know, so that would certainly bring into question his bias in a trial like this. If an organization he's a member of specifically, you know, is vocally, you know, opposed, you know, to this particular crime and activists in that regard, you'd certainly have to look at that and say, gee, somebody should have known that.
Well, it's certainly a question and it's worth a look. But under the standards for the fundamental error, it's not direct evidence. It's not plain on its face that this juror is biased. And that's the trouble with the argument from the other side. It's not plain that he's biased. Certainly, I do appreciate the court's position that there's a question, but that's not enough. With respect to that, I'd like to move on and talk about this discovery violation. Well, the record demonstrates that there is no discovery violation with respect to this whole bathroom issue. The victim in this case, the first testimony regarding the bathroom was when she was deposed. And this victim has never changed her testimony with respect to where this abuse occurred. She testified that the abuse occurred in the family bathroom and later described the family bathroom at trial as being a companion bathroom. And there's a lot of noise about it, but what's plain on the record, and it's a direct fact that can't be refuted in any way, that is that there was only one family bathroom, companion bathroom in the area of that restaurant, only one. So whether the victim described it as being inside the restaurant or adjacent to the restaurant or across the hallway or across the road, there's only one. So that really should clear that whole notion up of this witness making a change in testimony with respect to the bathroom, because it was just a change in a description and a distinction that is of no significance with respect to that piece. I also want to mention that there was no contemporaneous objection regarding what the appellant has characterized as a change in testimony. It wasn't until after the trial that this issue was raised. And again, there's no evidence in the record to refute that there is only one family companion bathroom. So it doesn't matter whether or not she initially testified that it was inside the restaurant and at trial later said that it was outside of the restaurant. The other thing that's important is that counsel indicated that during the deposition that the victim indicated that the abuse occurred in a single stall restroom. That is not the evidence in this case. The victim never made any reference to a single stall restroom. She was asked multiple times during her deposition whether the abuse occurred in the boys' bathroom, the girls' bathroom, or the family bathroom. Was repeatedly asked that question, and she repeatedly responded that it was in a family bathroom. So that's how that went. I do want to—
Ms. Lawson, before you go to the next issue, I want to go back for a moment on the jury misconduct issue. Am I remembering correctly that the appellant did not request an interview of the juror?
That is absolutely correct.
And does that make a difference to our analysis?
Well, certainly it does. It certainly makes a difference to your analysis with respect to the fundamental error issue. Because with the fundamental error, we're talking about an allegation of misconduct for a single juror, not the entire panel. And I don't remember the case off the top of my head, but it is in my brief. And when you're talking about the misconduct of a single juror and fundamental error, the question is it has to be direct evidence of that misconduct, direct. And it needs to be plain on the record. Because this juror was not interviewed, we're left with conjecture and assumptions. We don't know why he made the misstatements that were made. We don't know that. We don't know the answer to that. But the state's position is that based on the information that we have about this juror, it's tough to say that juror would have been biased.
Well, one of the issues that is troubling about a juror interview in this context, it would almost necessarily have to delve into his state of mind, which, as you know, the case law doesn't generally favor going into an individual state of mind during deliberations. But the other part that I wanted to ask you about, and I'll ask Ms. Goodman on rebuttal, or she can be prepared to address it, is the judge found or made a finding in his order that the motion for new trial could have been amended, or a request to amend could have been made. I don't remember the exact timing on this. Can you help me with that?
Oh, absolutely. I can tell you exactly how that went down. The trial was July the 12th.
Right.
Okay. And then the first motion for new trial was timely filed. That's not the issue. The court rendered its decision on October the 8th. Okay. So 14 days later, after the judge made its decision, that's when this new motion was filed as to the juror misconduct. But the rub with this is that 2 months in advance of the judge making its ruling, 2 months in advance, this information that forms the basis of this jury misconduct issue was known to the defense. So they had 2 months to massage this. Now couple that with the fact that there was already some confusing or misstatements with respect to the voir dire questionnaire and the verbal answers that were given during the voir dire. So there was a lot of time here to wrangle this in. And actually our position is from the very, very beginning.
Well, Judge Ward said in her order, one of the things she said was that there's no good cause for defendant's delay in finding the information on juror misconduct when the defendant could have made efforts to find the information before the time to file his motion expired. That's why the timing issue was something I wanted to ask about, because it seems that the investigators' finding of the information, did that occur before or after the ruling on the motion for new trial?
It occurred before.
It had occurred before.
It occurred before, and
Okay.
that's why it was untimely, because they
But
found.
that's what puzzled me, because Judge Ward says that they should have conducted this investigation before the court had ruled on the motion.
Oh, I see what you're saying, and I'm not exactly sure that language is lining up with what exactly happened, because the investigation was concluded and the written report with the findings from that investigation was also concluded 2 months.
That was in counsel's possession before
Correct.
the order on the first motion had been rendered?
Correct. That report was August the 5th of 2021, August the 5th, and the order was entered October the 8th. So that's 2 months in advance.
Okay.
I do want to, a lot of this case turns on credibility, and that's for the jury. But there are a couple of key pieces in the facts that I do want to bring to the court's attention. And that is that this victim tried to tell her grandmother at the time that the abuse occurred. After she was molested in the bathroom, she comes back out to the restaurant and she tells her grandmother, "I need some help buttoning up the back of my jumpsuit. And the grandmother says, well, why didn't Brody help you? Which is the appellant. And the victim says there was a problem. And the grandmother says, okay. And the victim goes on to say, but my grandmother never asked me what that problem was. And that statement right there, viewed in the light most favorable to the state, absolutely corroborates what this victim said occurred. There's also a lot of discussion in the record, actually not the record, but in the briefs, about when the actual incident occurred. But what we know from the record, and it's unrefuted, that the incident occurred during December of that year, when all of the parties went to Busch Gardens to watch the Christmas shows. The victim said that she was abused after the ice show occurred, but before the critter show. And the ice show is Christmas time. And there isn't anything in the record to refute that. So there was a couple of things that I just wanted to make sure that the court heard from us, that those particular things were in the record. I didn't really have anything else that I wanted to highlight. If there's anything else, we rest on our brief as to the other issues. If there's anything else.
Thank you, Ms. Lawson. Okay, Ms. Goodman, you're up for rebuttal.
Thank you.
Ms. Goodman, would you address that timing issue that I raised?
Yes, Your Honor. Essentially, it is true that the report from jury investigations was complete prior to obtaining the ruling on the motion for new trial, the first motion for a new trial. So yes, it's absolutely true. It's undisputed that that report was in August, and that sentencing and the motion for new trial did not go forward until October 8th, 2020.
Okay, because I was puzzled by some of the language in Judge Ward's order on the second motion. So I appreciate the clarification just to make sure that I was reading the record correctly. So with that in mind, doesn't this go back to, or in my mind, this goes back to Judge Morris's question, would this not be better sorted out on a post-conviction motion as to counsel sitting on the report for a period of time and not bringing it to the trial court's attention earlier?
Essentially, I can't speak to trial counsel. I have no association with trial counsel, so I can't say why he did not amend, why he didn't go forward on it sooner, and I can't speak to whether or not that it should be a subject of a 3850 motion, or if there was some other reason why. What I would like to clarify is that the issue of fundamental error and the issue of the motion for new trial are completely separate when it comes to the jury misconduct claim. They were raised as two independent issues intentionally, and that is because this is an appropriate issue for a consideration of fundamental error in a direct appeal posture. And the reason why I keep returning to this De La Rosa opinion is because the De La Rosa opinion is still very much good, intact case law from the Florida Supreme Court. And De La Rosa mandates that to obtain relief on direct appeal, an appellant must establish, one, that a juror made material misrepresentations or materially concealed information, two, during questioning and jury selection under oath, and three, that that's not at all attributable, or failure to discover the truth of what the juror was misrepresenting isn't attributable to the complaining witness. And I submit that it can be all those claims can be established in this case. And I would argue, I want to return to the issue of interviewing a juror, because that is not at all a part of the De La Rosa opinion, but it is, however, noted in the dissent of that opinion that the dissent is of the opinion that relief should not be possible without an interview of the juror to discover their motives or perhaps whether they misunderstood. But that's not the law. The law is the majority of opinion of De La Rosa for a direct appeal claim. Now, there is subsequent case law, which I believe the appellee is referencing when they talk about the actual bias standard, which would be, for example, the Martin case, the Boyd case. But I would also argue that this case more than meets the rigor of Martin and Boyd, because the facts of this case go far beyond what Martin and Boyd propose. And Martin and Boyd were both cases where any misunderstanding of any misrepresentation by the jury was somewhat explained by either some wrinkle in the juror's criminal history, like I believe one of the jurors had a previous conviction expunged, or there was some question as to the way that the question was posed to the juror that created some confusion. And that's just not the case here. And in this case, I think that we have more than enough to establish actual bias on the record, even if this court were inclined to consider this case under the actual bias standard, which again, I submit it's not the law of the land as far as a direct appeal posture for a jury misconduct claim. I believe that my time has now expired.
Time is up, Ms. Goodman.
So I will now conclude by just asserting that we believe that the appellant in this case is entitled to a new trial, and we would respectfully request this court to reverse and remand this matter for a new trial below. Thank you.
Thank you both very much. In order to leave our virtual courtroom, you need to find the leave button on your Zoom screen. It might be a little person. And you click that and you'll leave.
Thank you.
Right. The next case this morning is Davidson versus Dees.